Hello viewers, welcome to yet another festive edition of the Youth Roundtable. This episode brings to you a compound discussion on the issue of the trial of civilians, which is provided for under Section 119 of the UPDF's Act that provides for categories of people that can be tried or that can be subjected to military law. There has been controversy in the military court-martial in the past couple of weeks or days, and of course which has been climaxed or therein a comment by the head of state supporting and justifying the reason as to why the 2005 law is very important, owing to reasons that it has brought stability in the country, among other core reasons. Well, the issue remains a matter of contention, and we wait for what the Supreme Court will say in the matter or in the appeal of Michael Kabazuguruka versus the Attorney General, where the Constitutional Court declared that it is unlawful to try civilians in the court-martial. The decision was appealed by the Attorney General, and the Supreme Court did grant a stay of execution, and we wait for what the decision will be. Viewers, welcome. I'm joined by a panel of eminent young people that in no particular order I introduce them to you this afternoon. From my immediate left, which is obviously your right, is a gentleman all the way from the Forum for Democratic Change, and that is Najana Nkumbi group. He is also the chairman of the Forum for Democratic Change Youth League in Ibale. Masawi, always
Yes,
a pleasure.
thank you, our viewers. It is a pleasure to again be hosted on the Youth Round Table to see, as young people, what is our contribution towards national issues, but also be symbolic towards the direction we want some of these discussions to take our future. So thank you very much, Moses. I'm really privileged to meet a panel distinguished with a guild president and also a guild president candidate. Also, I think the three of us were all guild president candidates.
Except to me. So me, I'm the ordinary one on the show. Interesting. We are pleased to have you. Next to Masawi, he has really, forced my hand in terms of introduction. But well, the only lady on the show this afternoon is a former guild president of Makerere University. That's the Ivory Tower, and an active member of the National Unity Platform Youth League, and of course a very strong and renowned activist. Shamim Nambasa, it's a pleasure.
Thank you very much, Chidega, and hello to all our viewers. As already introduced, I'm Dr. Shamim Nambasa, and I think you forgot to.
Doctor is very important.
Yes. I'm a former guild president at Makerere University, 2021 to 2022, and a member of the National Unity Platform. And it's a pleasure for me to be here and to share and give our opinions of what we think that the direction of conversations in this country should be. And as young people, as youth, making over 78% of the generation or of the population, so it really matters that we shape opinions in the society.
It really does. It does. I agree with you. The last panelist on the show is a one-time contestant for the guild presidency of MUBS, but also now a strong member of the National Resistance Movement Youth League, and the name is obviously Nimrod Kakai. Ndugu, it's a pleasure always.
Thank you. I am always happy to come here to make a contribution. It is our role as young people to discuss what the future has for us. So I'm so honored to come here and speak my mind. Thank you for the invitation always, Chidega. And I'm happy to be joined my fellow young people here.
I'm your elder brother.
Masala has always said Ismail. I don't know if you're going to age, but he is. Yeah. So, but I'm happy to be here. I'm Nimrod Kakai from Namisi Indwa, and a very strong ideology of the National Resistance Movement.
Interesting. So let's just begin with you, Ndugu Nimrod. And you've put it out very clearly. The NRM, and by virtue of the President's opinion, is that it's okay for civilians who have breached the military maybe provision or therein to be tried in the military court-martial. Just what's your opinion about civilians being tried in the court-martial?
Thank you so much. Good afternoon, our viewers, once again. You know, for the past, I think, 2 weeks, I've seen a lot of controversies going around. The media in our spaces about civilians being tried in the military court, but most importantly, it came as a result of the arrest of Dr. Kizza Besigye, who is being tried in the court-martial. Like you have just asked, what's my opinion? You see, when the president came in power in 1986, the country from 1961 had gone through a turmoil of wars, insecurity, endless insecurity in the country. So in his plan to ensure that this country enjoys some relative peace that we have enjoyed for the last 40 years now, of course, notwithstanding the few areas that have some wars up to around 2007, that's when we could say Uganda is fully peaceful. There have been a lot of issues, and one of them is that most people who could commit crimes that are related to insecurity were mostly tried in civil courts. And in civil courts, some could get bail easily and go back and cause instability, or some could not be sentenced on time, and this caused a lot of insecurity continuously. But the NRM government in 2005 through parliament pushed for a law that brought court martials. When you look at the UPDF Act of 2005, particularly Part 5, Article 119, talks about persons who qualify to be tried in the military court. When you check it well, it talks that any person who threatens the security of the country, you have handed over yourself to a court martial. It doesn't specifically say you're either civilian or you're into service of the UPDF. It just says a person. So I think there was a lacuna there that they didn't specify. And I think that's what the court martial runs to, and it tries civilians in the military court. 2, the monopoly of weapons of security are in the hands of the UPDF. The military, the court martial relies more on intelligence than on evidence. The court martial of this country relies more on intelligence than evidence. Why? When it comes to security, anything small can cause problems for the country. They don't allow to first gather every evidence for them to proceed with a case. If the court can go back and check a number of cases, as long as they have intelligence that so and so Chidega Moses is trying this, they will not give you a chance to continue. They will get you immediately as they gather more evidence. That's why you see colleagues who have been, people who have been there for some years still gathering evidence. That's how it operates. It's more of an intelligence. I call that it depends more on intelligence, not so much on law.
I don't know as someone who is in the legal profession, I don't know where to fit that analysis, because courts of law are ideally supposed to be evidence-based.
I know, and when I say that, I know even our viewers are shocked. Why? Let me now get you to why it operates more on intelligence than on evidence. When the president realized that these courts of the civil courts delay these cases, and basically because of the backlog in these courts, there's so many cases, robbery, adultery, there's so many cases there that sometimes they don't expedite the process of these insecurity cases. The court martials come in very fast. Why? For them, as long as they first have intelligence, it is very hard to try someone in a civil court without concrete evidence. Yes, as much as the court martial is supposed to have to deal with evidence, but for them they start as they collect evidence. Now, getting back to your question, I'll keep explaining that.
Because I think let's first have our opinions first, then we can delve into the details.
No, let me finish.
And just speak your opinion.
Yeah, let me finish my opinion.
Okay, just in a minute. Okay.
So in 2005, when this act came in to try civilians who are related to issues of security in the country, that if they find Nimrod today with a gun that is not licensed to have, I have handed over myself to the military, to the EPDF, and that hence I'll be tried in the military court martial. Lastly, it is because that through this process, they have tried many people who could have caused problems to this country, and that's why we're still enjoying peace for the last 40 years.
Okay, interesting. Shamim, your own opinion regarding the trial of civilians in court martial?
Yes, thank you so much, Shidega. And my opinion is very clear, and I'll go straight to the point. That if we went back to see when they were founding or starting the court martials, what was the purpose of these court martials? And so that is why I don't understand where Comrade Nimrod is taking us all around, because even in his letter that he released, the most recent letter from Mr. Museveni, he says that these court martials were established to deal with serving soldiers. And then he puts an explanation that since you've gotten a gun as a civilian, you've then made yourself a soldier. But the point remains that court martials were established as a disciplinary committee to put together, to organize and see that they make sure that serving soldiers actually behaved in a particular way and they were answerable if they did something wrong. And then you find that as of today, the court martials are being used to settle political scores. That we have seen to a large extent the people being tried in these court martials. It's either going to be Dr. Kizza Besigye, it's going to be Olivia Lutaya, it's going to be people that associate with the other side as opposed to the government. And if we're saying that we are trying people that are threatening the security of this country.
Do you just want to mention General Kaleka who was tried there as well?
There are very many people, yes.
Funza, yeah. So
What I'm saying is, if we are looking at people that threaten the security of this country, the likes of Jamil Mukulu, the people that bombed the Twin Towers, in Chadondo and why, these people are being tried in civilian courts. Yeah. So why then is it selective? So it still goes back to the fact that for me, court martials are being used to settle political scores. But then also, if you look at the type or the caliber of judges in these court martials, you do not expect for people to get justice from these court martials. So for me, I would say in conclusion that court martials are being used as a political tool by Mr. Museveni to silence people that go against him. And even all the other explanations of clogging of civilian courts and all that, those are all just excuses to support what he's actually doing.
Okay, just to follow up on that, is it your opinion that if a civilian is found in a situation where they're putting the country's security at risk, should there be an avenue for the court martial to try them, or it should be a pure civilian?
It should be
a civilian court.
If it's a civilian, let them be taken to the civil courts. Let the justice system be trusted to deliver justice. And we've seen rulings from even the Supreme Court from the Court of Appeal, and they were very clear that civilians should be tried in civilian courts. Let court martials, because I believe even the training that the judges in the court martials have is specifically for them to deal with soldiers. And if we look at, I've seen many lawyers come out to question, the kind of education the judges in court martials got, and I think you'd be best positioned to explain that to us. I don't think that they qualify.
Actually, none of the judges is a lawyer by training.
And so is that
except the court advocate.
No, just in the APDF Act, it says that anyone not below the rank of a major qualifies to sit in the court martial.
Which is
is that actually right?
Which is in itself, I think,
wrong,
a shortcoming.
but it was done by Parliament.
And that is where now the problem
not
is.
everything that is in the law is lawful. They are,
And those are things that we should be addressing. Those are things that we should be addressing, other than just sugarcoating the whole situation. It's very wrong.
Okay.
That's what I want to hear.
Masawi, your own thoughts.
Thank you very much, Moses. I've listened to my fellow panelists. I think my brother Nimrod did state that President Museveni came to power in 1986. He just became president in 1986, but he has been in power for the last 60 years. He was an assistant secretary in the Obote government, and Obote and Mutesa. I'm sorry, since I'm on Buganda land, I say Kabaka Mutesa. So since he was a king, fell into disagreement. Obote treated Kabaka Mutesa the very way Museveni has treated Besigye. He would issue the same letters that in the National Archives Library, you can go and read them. The very drama Museveni is acting was acted by Obote. Museveni was the assistant secretary. As Idi Amin comes to power, through all that time of the Pidgeot Constitution, he's not doing this because He's more experienced in knowing how to control. It is a weapon, is what I'm trying to communicate, because I don't want to go back into his letter, because this is a trend of all our leaders since independence. Whenever they are dealing with a political opponent, they seek justification. When we come to 1971, he is in Dar es Salaam with the group and they return. When Yusuf Lule was president, you can read about it very well, that Yusuf Lule had a colonel called Colonel George Nkwanga. President Museveni, who was Minister of Defense under Yusuf Lule, they are saying he came to power in 1986. He was a Minister of Defense under Yusuf Lule. Wanted to go and get military training, and Colonel Nkwanga refused. Colonel Nkwanga, in one article he wrote, says Museveni scared to kill him because he wanted to belittle him not to attend military training. That is the Museveni. The very Museveni campaigned for Paulo Muwanga in the military commission to take over Yusuf Lule, to the extent that he is on record for donating his Land Cruiser for Paulo Muwanga to use for campaigns, so that he becomes the what? The next president. We can still leave that case and go to the Nairobi negotiations. What was on paper? Who betrayed? Oh, where, because this country has people who have read about criminology. And I think the first certified criminology doctor in Uganda was Dr. Andrew Tankome Kaira. How did Kaira disappear? Actually, Dr. Besigye was a Minister of State, while Kawanga Semwogerere Paul, the late, was the Cabinet Minister of State. When Andrew Tankome Kaira, a full doctor of criminology, was in Luzira for 2 years, just in the same scenario, and he had helped President Museveni both in the bush by donating his guns, by forming UFA to come into agreement in Nairobi, the Fedemo gang to bring it, to donate it to NRA in the bush. Then we come to such a scenario that he was appointed cabinet minister for Minister of Energy in this country. When President Museveni had just taken off office, by 1987 March, just 1 year later, he was dead. But before he died, he was in Luzira for trying to overthrow the government, which he was a Minister of Energy. Right? If you read about Dr. Tankome Kaira, here in Uganda, there is a book called The Price for Freedom. They will point for you whom Tankome Kaira was and what values. You know, President Museveni has reduced this country to his drama of the politics of 1970s, 80s, of do something wrong, then you create a justification. First of all, the existence of the military court alone belittles all of us here to begin discussing something in a country which is building institutions, the both democratic, both legal, that you still have a military court where someone to be a judge, you just have to be a major. Such lawlessness. I think as you guys, is why when I'm always invited to such debates, I had one on a radio on weekend where they would question you, tell us the contribution of the military court martial to how it has promoted security. Really, how do you begin? Actually, even in the FDC perspective, I've had a lot of controversies. People who said that, why don't I feel sorry for Dr. Kizza Besigye? He was a Minister of State here. When he saw, I've given you the precedence of Kaira. Kaira was murdered. In the morning, Dr. Kizza Besigye, as the Minister of the State, was the first to report. He's on record for telling us such stories. But he knew that one day, things go around. He never knew he would be in opposition in a few years to come and suffer what they had promoted as promoters then. Today, he's the very man he promoted is the one issuing letters justifying why he should be there. They have reduced lawyers to shallow conversations. You even fail to trust the lawyers because they have reduced them to discuss shallow. You know, even Amin, after capturing Obote, issued letters justifying how Obote had changed from what they fought for, was now a social Marxist, is no longer a liberal. whether Mwanga, after ensuring Lule and knowing that the Baganda still believed in Lule and never believed in Mwanga, but Museveni, his vice chairman and head of the military commission then, was the man behind Mwanga. He also issued same letters. At some point before this court martial comes in 2005, when Mr. Museveni was Minister of Defense, the group of Lule that he writes that attacked Nile mansions where him and Mwanga were all assassinated on streets and arrested for trying to overthrow, but because they were in protest. Kaira's family, pregnant wife and kids were arrested until Kaira comes out. That is how he entered prison. His wife and kids were arrested in a prison by Mr. Museveni, who was Minister of Defense, until he came out, so that his going to prison was exchanged for his family. Major General Mount tells us of a story where for Kaira, after the court, DPP found that he was innocent, and Kaira refused to leave the court premises because he had seen a drone of that time, which was a pickup, outside waiting to take him back with soldiers, that he had to, that Major General Mugisha Muntu had to pick Kaira and deliver him home to avoid the tendencies of picking people court had found innocent. Because these are not new, there have been practices. So it is very unfortunate that a country where we are now to inherit, we have been reduced to tendencies.
But you know, Masawi, court martial is not a new thing. Even in modern democracies like America, they have a court martial.
I think you fail to isolate one thing. Look at the principle of application. Does the American court martial apply like it is applying here? So have you ever seen any politician? David Tinyefunza was the chief head command of military forces when Kaira was killed here. I use Kaira because Kaira and Museveni were of the same level and same grade. And he was arrested in Luzira, kept there for months. He was assassinated in a time when he was a cabinet minister. And he's famous for what he stood for. General Tinyefunza was a military commander. Then years later he was tried. Kaihura was tried. If the court martial is made for men who have been in the army, like the former presidential aspirant, a former lawyer like you who was also there tried, is now a lieutenant general, a full general.
Yes.
He was a minister for security some years back.
Tumukunde.
If it is made specifically for, I think we need to audit its application. We have used it as a weapon of keeping Museveni and to judge who has tried to pass their limits towards coming towards us.
Okay.
But I'm giving you a preamble that in Museveni's tactics of militarism and militarizing a nation, he has done this before. Why a Minister of Defense under Paul Mwanga, during negotiations in the 80s, you can look for formation of how he forms this NRA rebel group of his. He betrayed other people using the same tactics of commissions and what. So we have been able to always discuss these things shallow. Uganda politicians, they are shallow. They are now attacking you lawyers to make you also very shallow. You will be reduce everything to be very shallow. You write letters narrating. What is the crime of lawyers having a discussion around the court martial? First of all.
Okay, fair enough. And I get the depth of your analysis. But Nimrod, I want to bring you back in. And the question is, the capacity of the military court martial is that you have a bench of judges where none of them has gone through elementary legal education. Then you have one judge advocate whose role is advisory to court. His decisions are not judgment or law in itself. They only advise court, then court makes a decision. So the question there is, where does that leave the quest for justice in a military court martial, where the people who are supposed to preside and administer justice have no appreciation of the law of evidence, criminal law? So where does that leave
This is a generation of too much education. We have guys who don't want to study, but they want to judge to Mukunde, a lawyer.
So, yes, Nimrod,
Thank you.
is the capacity of the court martial
thank you,
in question?
You know, it's very interesting to hear all these stories. I think one thing we should not forget is the history of Uganda. Our history should be able to teach us so many things. Just because of time, we may not go there, but let me just go to...
No, take your time. Feel free to...
Okay.
Yeah.
Let me first answer the question. The capacity of the military court to offer justice. You see, when I started saying this thing, I said something and you didn't get it. I told you that for the beginning, military court doesn't operate fully on law. It operates more on intelligence than evidence. Now, when you understand that, you'll now understand the capacity. Why? I'll give you what the president wrote in the letter about Karamoja. For him to have some relative peace the Karamojongs are enjoying today, to make sure that at least 900 criminals are behind prison or the bars, they made sure that the 3rd Division court martial expedites their trial, basing purely on intelligence that so and so has a gun in their home. This young person has this. They are planning to rob this. After collecting all of them and establish the peace in Karamoja, they're now saying, okay, let's now start revisiting to ensure that the hardcores are separated from those who were not so much serious with disorganizing Karamoja. Why am I giving you that background? That the military court, we believe that being a major in the army is not something you wake up and become.
Now, how did Mohozi bypass all those?
He went through all the process. Are you saying he was not trained? Are you saying he didn't do things that qualify him to be a major?
By why does he do things like quit in a way which doesn't?
You see, you cannot discuss his personality or character vis-a-vis
we
the
have a
ranks.
leadership code of conduct, chapter 14.
Okay,
of
maybe
the
we shall have
Constitution of
another
this
day to
country.
discuss General Mohozi. But me, I believe, with
There are
honest
those who have
respect,
been there by
I
his,
believe that there's no
their
one who
parents
becomes...
were good followers.
I don't think so. I
They
don't
are
think
there.
UPDF operates
I don't
on
want to mention their names
tribalism.
here, but
Okay,
they
you
are
tell
there,
us.
many.
But I don't believe that UPDF will promote Nimrod just because I'm a friend or I'm... No, there are processes. So for you to become a major or above, become a colonel, a brigadier general and all that, there are processes. And you are trained enough to make judgments.
Trained in what sense? You're trained to hold the gun and fight.
That's
not
not
to give
let's not
judgment in
discredit
the
That's
process.
education.
No.
That's
If
what
they
Let's not
don't want to
discredit
study,
education.
Museveni has tied us to discredit
let me
our
tell you
own
one thing.
education. That
One
is
thing
a
You
you
can
know,
have
mistake.
as much training. I have as much training as a
They don't-
pharmacist, but I can't
actually,
say I'm well
Hey,
trained
that,
to become a judge, to offer
no,
judgment.
even to say
No,
you give
that is
consultants
wrong.
Let me tell you one
on
thing.
medicine because you know
No,
you
those
you
are
don't-
protect me
rumors.
to make my
Okay.
point.
Okay, please. Yeah.
Thank you. Let me make my point. The mistake you will do is for you thinking that soldiers are only trained to hold a gun and shoot. No, actually, the work. I don't know.
I'm also
Me,
not
I've been
doing
trained as a
engineering.
soldier.
I
had
do
a
a lot
chance
of
to see
things
them.
besides
Being going
engineering.
through
I don't. I've also
Please,
touched a
Nimrod,
gun
I think
like
let
this.
us make-
I
let
don't
us-
also need do
Don't, I hope you're
engineering.
not counting Chankwan's
But do you
training.
think I can sit and judge?
No, let me tell you. That's what I'm saying.
Actually, me, I've
They
had
go
an
through a
advantage
very
to do a
vigorous
law
process.
They go
course.
through a vigorous process for a particular purpose that they're supposed to
Now,
serve
that's what
in
I'm
the
saying.
UPDF,
We
not
believe
as
that-
judges in courts of law.
And that's why there are judges in court martial. Because they
They
are being
are-
trained
but they
fully,
shouldn't be.
fully to be there. They have been trained fully to protect the country interests there.
To protect which
Interests
interests?
of the country,
Or
including
interests
security.
of their leader?
No, I don't think they work for. If they change the president, they should protect the interests of the country. So
It
they
will
are
be one
well
of the
trained.
first things we
They
shall
are-
abolish
the way-
after the downfall of Museveni.
Which we
The
may
first
not be
thing
now.
will be
It will take you more 40 years for that. But I'm telling you this.
for you, but not us.
And I'm telling you this, that they are well trained to make sure they fit in the court martial and make judgments on the interests of the country.
Nimrod, one day you'll be
Interests.
tried by a P1 student. You'll be there.
As long
praising
as they
him.
make the right judgment, I don't mind.
I
As
don't
long
think
as
they have
are
the
trained
knowledge
to make
the right judgments.
exactly.
They do not have
Are you
the
doubting
knowledge.
that they don't have the knowledge?
I'm very sure they do not
The
have
beauty
that
is-
knowledge because I have
the
seen
beauty
them
is
argue in
in
the
this
court
court,
martial and they do not have
Kano,
any
we are going to
background on
witness-
the
Their
law.
court cases
And that's what we
always
judge
end
people
with President
against.
Museveni pardoning before they even
Yes.
set a
Listen,
judgment. So
the
what
beauty
is the
is-
essence?
So
It
what
is
is
just
the
a
lawyers-
I've
fashion
never
of
seen
talking.
them
lawyers
do
are allowed to go and
anything.
make their case in these courts. So are you doubting that we shall follow?
Okay,
We
give
shall
us
follow
two
that
clear
everyone-
judgments where a
everyone-
court case came to end in the court martial. Without
No, the beauty
president
is that
interfering.
we're going to witness. I hope they grant Mother Karua permission, the license to go and represent Dr. Kano. We think she's one of the best lawyers in Kenya. I hope she will do work here. She's gone to those people who you think they are not qualified to make a case.
She's only going
So-
there because that is
so-
what is there.
exactly.
That is
So-
what
so
we
So you
they
think
are-
used to.
let her go
Museveni
make a
set a
case and we shall all
justification.
see. So me, my point I'm trying to say here is, Kundo Chidega and my friends here, is that don't doubt their capacity. For
We
someone
actually
to be a
don't. We
major,
have all
to be a
reasons to
colonel,
doubt
to be a brigadier general, is not by mistake.
Nimrod,
It's not by chance.
Even her,
It's by process.
Being a pharmacist, being an
It's
engineer
not
is
by-
not a
It's not by
mistake.
mistake.
Uh-huh.
We
I've done-
even
I've
Chidega
even
here
studied
being
a lawyer.
a lawyer,
It's not
he's
a
studying.
mistake.
It's not by
Exactly.
mistake. He went back to
Don't
so
tell
he
me
didn't
I
go
should
for
go and
military
sit at the
training
court
to
martial
become
because
a
I've
judge.
No, if they trained you
Uh,
to be a judge in the court martial, that's when you qualify.
No, they were not
But
trained to be
are you
judges.
sure
They
they're
were
not?
trained
Okay,
to be
which
majors
school is there
and
that trains
lieutenants
them?
and whatever.
you. Now, let's-
Chankwan
Okay.
Singh.
Now, let me
Okay,
tell you
fine.
one thing.
Yeah, because you see,
We want to know
Nimrod,
that- yes.
Nimrod,
I think Nimrod should
my
make
question to you
informed
in this point is
They
that
are
you
very
see,
informed, just
in this
that you
point
are-
is that you
you're
see,
biased.
in the civil context,
Yeah.
when the state is trying an individual, the state presents its evidence, right? Which evidence must be, okay, the state presents evidence, which evidence is challenged by the defense.
Yes.
So in this case, when you're saying that the military court martial tries individuals basing on intelligence, what check and balance
But you're a student.
does the
Does that
state
make
provide?
sense?
No, that's why I'm asking
You're
him.
a
Yes,
student.
let me
Does
answer
that
I am
statement
asking
make
him.
sense?
I am asking him. Then, what is there to counter
Yes.
the
What is going
intelligence
to
which has
happen-
been gathered,
Well, yes, what's going
upon
to-
which court is going to take a decision?
What happens is this.
Because intelligence
One,
should
what
lead
is
to
going to
evidence.
happen
Now,
is the court martial is going to present their intelligence, their information, that Dr.
Their
Desije on
rumors.
such and such a day, we found him doing this and that and that. They will present it. And the defense is upon the defense team
Yes, to now
to now present their case that you are wrong.
and to
And
counter
for them
it.
to present and to counter that, they will present it. Don't think they have nothing. They have something to present.
they'll bring the
And-
two
and they'll
pistols,
bring-
like
they
they
put
brought
them there.
27 on Bobby Wine in
Whatever
Arua.
the case.
They have always had those guns they keep somewhere in a
so-
store.
That- that's the
Shamil,
Malay
I-
argument here.
I have to bring in Shamim. Okay, yes, but yes.
Yeah, as
you-
I conclude, that it is very wrong for us to sit here and doubt the
I think even
qualifications-
Bobby Wine's case is still there. The one for Arua.
and doubt the qualification
I want to, yes,
of the judges in the court martial.
yes.
They may not be fine lawyers, as you may think, but their role is to present. When they present, it is going to be upon the defendants. They are given a chance to choose the best lawyers for yourself to come and defend you. Let me tell you, even the court martial system, there is also a defense lawyer.
Yes, there is.
You know that. So even if the team here fails, they have a chance to use the court martial lawyers to defend themselves, to defend. So in conclusion, I'm saying here is that the contribution and the qualification of the court martial, as I said from the beginning, that a major in the UPDF who has been trained well, gone through the process,
Is qualified
can
to be
carry
a,
the
a
interest
judge.
To be a
can
lawyer.
carry the interests of the country,
Yeah.
and most importantly, the security of this country.
Interesting. Shamim, we have had several lawyers appearing before the court martial. Is their appearance and their continuous appearance giving jurisdiction to this court martial? Because if you're saying that you don't believe in that court, then why
Yeah,
go there to make a case?
I think that is where actually we needed to sit down. Actually, I think where lawyers need to sit down and assess these issues. Because if you believed, and if we actually believed that the court martial, which is a disciplinary committee for soldiers, is not supposed to be a court for civilians to be tried in, we shouldn't even be presenting ourselves there. because once we do that, we're giving it legitimacy, which it shouldn't have. And I know even in the case of Kawazi Guruka, he made it very clear he didn't want to apply for bail. He didn't want to actually be tried, and he went ahead to appeal. And that is where we are now waiting for the judgment from the Supreme Court. And I think for me, that was a right direction that had been taken. That was very strong of him and a very good idea. But then if we are continuing to say that, look, you know, the people that you're defending yourselves before, because for me, from the medical profession, I would think it's more of a surgeon or a consultant, you know, trying so much to explain to a one Nimrod why this surgery should be done this way, because one is more qualified than the other. One is supposed to be in the courts and one shouldn't. So if we are having our very fine lawyers presenting themselves before the court martial to make arguments, and you know, we're finding it that it's actually illegitimate, so it actually doesn't make sense. It beats logic. So for me, I would think the best that we would do right now is to have a campaign and fight actually against civilians being tried in those court martials, but then also not have our lawyers present themselves there.
How about with regards to the court martial and the bench, the judges? Nimrod, in his view, thinks that these are qualified enough to dispense justice. Yeah. I don't know. What's your opinion?
First and foremost, I want us to look at the appointment of these judges. How are they appointed? They're
appointed like any other judge, even in the civilian.
Judges. But how about how then is their term of office concluded? Is it the same as the other judges that are in the courts of law? Is it the same? Because from what I know is that for the other judges, they have that sense of protection, you know, for their tenure, for the time that they will be there, and they can make clear judgments. But the ones in court martials, we know that any time you can actually be called back. So you find that they have to pay allegiance to the appointing power. So for me, it's you know, questions what their judgment is going to be. If it does not align with the president, who is the appointing forces, or the appointing power, then they risk losing their position wherever they are. So that alone makes me question the kind of judgment they're going to give, or if they're going to give us justice. But then from what I know, and I you know, I give merit to education a lot.
So does it matter that they should be lawyers? Does it matter in any way?
That's where I'm coming to. That I believe that for you to be a judge, you must have a training in a particular, you know, kind of knowledge and practice, because from what I know, a profession, and if I'm wrong, you can correct me, but being a judge is a profession. And you know, a profession is defined as a particular kind of way that has a group of people that undergo a specified kind of training for a given period of time. They have some level of knowledge, they're paid for it, and they have, you know, but then you find that we have people that have undergone training as soldiers, and then they're now becoming judges.
Okay, can I ask a question? You sat in the Makerere University Council.
Yes, I did.
Is that correct?
Yeah.
The Makerere University structure has a disciplinary process.
Yeah, we have
that staff can be subjected to.
Yes, yes.
Do the people who preside over that committee, are they lawyers?
So it is a disciplinary committee,
exactly,
right? And
that takes decisions to even dismiss lecturers, right?
That. Yes. And they have guidelines that they follow, and they have been the composition is that they are believed to actually have the necessary kind of judgment that they
are
need.
they lawyers?
And
is the
they
question.
are not lawyers.
They're not lawyers.
But
Exactly. So what difference? What difference does it? No. I know what I'm trying to get to.
Yes.
Yeah.
Yes.
Because
and the reason we're saying it is a disciplinary committee. That it is listening to particular cases around discipline in a given group of people, that you must be a Makerere member of staff, or you're a student, or all that. And I wouldn't have an issue with a court martial if it worked as a disciplinary committee
for the
serving soldiers, as it should be. But now it can't be listening to cases of civilians. Because for me, I would believe that if you told me this, they have the training, you know, to handle the discipline of you know, that soldiers and all that, that is very okay, and that is what it should be. It shouldn't then be turned into a court to listen to cases of civilians upon which they do not have a jurisdiction. But then also the other issue comes that we have a ruling from the Supreme Court that actually says if you've been judged in the court martial, you cannot appeal, you know, to any other court. But even if you came to Makerere, you know that we can appeal. You know that we can. So
judicial review.
Now actually justice. So those are some of the things that for me I find the court martial is overstepping their grounds.
Interesting. Masawi, let me get to you. I have privilege of having a legal background, But I know that an appeal is not a right. There are appeals that are statute in nature that must rise from a statutory provision for you to appeal. So if the military court system does not provide for an appellant court to the civil jurisdiction of court, where does that leave the fate of even the military officers who have been tried within the court martial to the highest appellant court within the court martial, but still feel aggrieved, like the case of Opoka, who has traversed all the military court system and he still feels aggrieved. Then he seeks to appeal in the Supreme Court, and Supreme Court says that they have no jurisdiction.
I will just speak of from my sister. The former guild president left it at. She gave a clear example of what a court martial should be. Whenever the idea of bringing the court martial into the UPDF Act was Mr. Museveni idea. He knows whether he choreographed it from China, wherever he stole it, to bring it and sell it to people who are graduating from a reform agenda to a multi-party system who are seeking survival. See that they pass it.
But when President Museveni eventually, what will you have to talk about?
I've given you a history that whatever he's doing is not new. There was actions of court martial before, but now they were not justified. People used to kill people. People used to arrest people in prison. In Polo Muanga, in Obote, where he also served as Assistant Secretary, in Yusuf Lule, where he was Minister of Defense. Here is why you see that there is even no appeal system. It is a tool.
So to you, everything is about President Museveni.
But he's the one benefiting. So yes, he has been arrested for what? Because he's fighting Kidega.
Because your earlier assertion, you made.
I've told you.
You made the point that there have been.
You're a law student.
There are other
you
people
believe
who
in
have,
what they call a
promoter
promoter, right? In law, they teach you who is the promoter
of a company. Yes.
Of a company. Who was the promoter of the court martial? A promoter is the sole vision bearer. And when I started the company, to believe that Masawi even started it.
But you know that also promoters are do not warrant, how should I call it, payment or something. They only do the work of voluntarily promoting a company and are not entitled to any payment or compensation in return. But you see, besides that, you made the assertion here that Dr. Kizza Besigye has played a role in creating this kind of military system.
They were the promoters.
So why are you insisting on only the individual of Museveni, and yet this could be a more structural, a more bigger structural issue, and putting it only one individual could be being short-sighted?
I'm giving it one individual because you brought us to discuss his letters. Did I come here to discuss your letters? Yeah? Because he's the fond of the court. He wrote the letters. We have been reduced to waste 2 hours to discuss letters that don't make common sense, that create contradictions. Kidega, let's avoid Nimrod's argument here that a P1 graduate who joined the military at the other age because he was mature and was later promoted for loyalty is going to judge Kidega because Kidega is now appearing. The justification that has reduced all you lawyers who have studied from like the Kwagozu went to UK and where to go and stand in front of people who have never seen a legal exam. Not even introduction to legal methods one. And then they are the ones to give you a jurisdiction. You be there, they send you away to no bail. I think the drama alone, and I've given you that whenever you want to discuss, let's look at the preamble. Which kind of people have always been judged in this court? There have been people who have been with him but got dissatisfaction politically. Even Chitata was NRM. When he was taken, Chitata and Besigye have the same case. Chitata was caught with a golden pistol in Rovage, a toy gun. Besigye is alleged of having 2 pistols in Nairobi to overthrow Uganda from Kenya. First look at even the composition of the case itself as a lawyer. Does it, in a country that is advocating for East African community Jumuiya agenda, does it create sense, set a legal precedence?
that there is still hoodwinking of people and trespass. Then we also look at the other examples. I gave you an example of the Honorable Kyagulanyi in Arua. After they were arrested in a hotel, you saw guns were paraded, the full table. They included Wadiri, Mabike, Oto. These were people I know very well. I'm a neighbor to Kashani Wadiri in Nambol. All the guns, I still ask them, where are your guns when you are taking? Were you refunded your guns? In the end of the day, he says intelligence. You wonder where that intelligence always goes. You cannot use... The court martial may be used as a tool, but it offends us who are to live here more because it limits people's potential of building institutions like the General Court.
But where does that leave the errant soldiers? Because if you're advocating for the total abolishment of the court martial, then what disciplinary mode are you proposing for the serving errant military officers who have the privilege of wielding firearms?
You did ask her about why Makerere University has a disciplinary council.
Yes.
The military has a disciplinary council. And if it is the court martial, then it should be the objective of its work.
So meaning,
you're in the Uganda Medical Association?
Yes.
There's something we need to make it clear.
You will not reduce me to discuss Museveni's ideology of managing Uganda in the name that the court martial is very legitimate.
The issue I want to make it clear is that it is not correct for us to say that every civilian that is tried in the court martial has subjected themselves to the court martial. How? There is no Nimrod Kakai who they have found a thief and being taken to court martial. It's not there. Tell me one that they found you robbing a bank.
No,
that's why I'm saying the moment they find you with materials that belong to
you
the
say
UPDF,
they don't have to find you, they just have to have it.
or the moment they have information that they will present to you, because the data present it. The moment they have information on you that you have materials that belong to the monopoly of UPDF, you have handed over yourself to that process. You have qualified yourself to be a soldier. And that's why they will try you through that disciplinary committee called the court martial.
I think
that's why they don't take people, civilians who are robbing banks or doing anything else, until they find you with something that qualifies you to be a soldier. Or
I'm not arguing the procedure
and you're having
issues.
it as a civilian, and that's why you're going to that court martial. Not anyone else. So I think
I'm not arguing the procedure.
So meaning you're saying that you cannot make your bed and lay on it. You cannot want to possess military attire, have guns, but at the same time you want to see civilian.
The moment I own a military attire and I'm not licensed to own it, and I'm a civilian,
then you
I have
pay the
qualified myself
consequences.
to be a soldier, and they will hand me like a soldier, and that's why they'll take me to that disciplinary committee.
I think you tricked me into the discussion I avoided at the start. That I'm not arguing any procedural issues of the UPDF Act. But even its existence itself and the intentions, its preamble itself to why it exists, is why you have seen that me have discussed more of the promoters and who have been the beneficiaries of its existence. Not the Nimrod as the difference between me and Nimrod is that for him, maybe he has seen any benefit. But me and Nimrod, if I'm to not lie, we come from political families. My dad was an MP and Obote is Simon Mlongo, where he comes from. We have grown in families that are political. So we know what a political intention is and what a goodwill is. It doesn't need to be
what I know is that the beneficiary is that the country is secure.
It's secure.
That is the beneficiary that we all share. All of us here, we share a peaceful state.
So
that you don't have errant army officers running around with guns and
even
shooting.
civilians moving errant and shooting people, or destabilizing the country. So that beneficiary, it cuts across. You cannot limit it to Nimrod. Or if Karamoja is stable because of the court martials today,
the country is stable.
Are you saying that Karamoja people are not happy that they are stable because of the court martial?
We want to say that Karamoja is the reason for introduction of the court martial.
I'm just
and then you give me how many Karamojons have been there.
I'm giving, no, there are 900 that passed through the court martials there. But I'm telling you that one reason is
First there or you read the letter?
That is saying the president is lying.
The court martial here in Uganda is known for
It is not like.
well,
So
for
my
me-
point here is that we are all beneficiaries of the secure state.
It is a
And
tool
if
of
the court martial
operation.
is helping us to ensure that we live in a peaceful Uganda, we should also embrace.
Chidega, for me, I think thinking that the court martial should purport to do the work that the actual court system or the actual justice system should be doing is where we make a mistake.
Duplication,
Because that is
wastage,
because if you are saying
gambling,
that they have taken all these people that are threatening and what, these are civilians that could be tried in the courts of law where they are actually supposed to be tried from. But the issue we are having today is that the court martial is being used as a weapon, to settle political scores.
That's
because
your interpretation.
because
It
then
can make it
what is
correct.
wrong with you
Are you in this
trying
country
Dr.
to say it is
Kemp
your
in the
interpretation?
civil courts of
You wait,
law?
me, I don't hold that
speak
idea.
that I also go
I don't-
into power and I
No,
judge you.
I don't
there
hold the
and give
idea
it.
that they are using court martial to settle political decisions.
No, but
I don't
why is
hold
the
that
court
idea.
martial purporting to do the
don't
work
hold-
that the courts of law should actually
has
be
not
doing?
purported at
That
all.
is vulgarizing of the court
Its
system.
jurisdictions are clear.
Its
And it's still in
jurisdictions are clear
jurisdiction.
and they should be serving officers. That is what we are
And
trying
I'm
to
telling
say.
you, when
that we are not
when I
expecting
qualify
justice.
myself-
We are not expecting justice to come from these court martials because of the
the
issues
people
that we have
stealing
raised.
in Namugongo, why aren't they taken to court martial whenever they are arrested at police stations and taken to civil court? We see people
Exactly.
are caught
No,
with
why-
guns,
why-
pangas,
are-
military
yes,
weapons.
because
They are
then-
always taken to courts in
The
our
people that
villages.
shot
Why
even
is it so
Yagira's
selective
brother.
in who it
That
takes?
is my issue, that it is very selective and you can't do away with the argument that it is
Why
just to
did
settle
he wait for
political
Besigye to
scores.
write letters? Why didn't
is
he write
Jamil
on other?
Mukulu being taken to civil
Because
courts?
it was
court
a
martials,
tension
to
issue in the
civil
country.
courts.
As a president,
But you
No, why
say
is
there
Jamil
is
Mukulu
now
being
tension.
taken to civil courts?
What is tension and intelligence to you?
Auntie, let me tell you one thing. When
So
the president,
Mukulu is far
Mukulu
better
is far
than
better
Besigye.
than Besigye.
I'm telling you this.
No, first
Who
answer
are-
that.
No, let me, you see, this
We
is the
are not
moderator.
blind.
Is the one who asked me questions.
Okay, we are asking you, is
Then
Jamil
my-
Mukulu better than Dr. Kebi?
Who
The
is-
threat that Jamil
You
Mukulu
see-
put on this country, is it smaller than, the threat that
That's
Dr. Kebi
that's
is
intelligence
imposing?
to decide. That's why intelligent people have to decide. If I'm sure you had the audios. If someone is plotting to overthrow a state, overthrow a legitimate government, there's no way you can deal with him
Don't believe
the
in
same way.
things that are manufactured.
That's also to you. I don't know how you measure manufacturing. Me, I don't have any system I use to manufacture or to understand that this is manufactured, this is not. I don't have anything.
You simply had the
You simply
Audio.
believe
Had the
whatever they
audience.
give you.
Like,
So
that's what I
intelligence-
had.
So that is the intelligence.
I don't
So
consume
that is
intelligence of the
intelligence.
state. It's consumed by the right people. All I'm trying
Your
to say
state
is,
has very
all I'm trying to say
interesting
is, it is dishonest of us, young people, not to be aware of the obvious facts in this state. If the court martials of this country have proved that whoever they have got on an issue when it comes to security of this country, they have hoped to stabilize it, and the country is moving on peacefully. It is wrong for us to say they're using it to settle political scores.
They actually are.
It is
They
wrong.
actually
There were
are. Because
courts
we have
here
not
before
seen
they
the court
came.
martial come out to give a judgment on any of the cases of the people that have been taken
Okay,
there.
okay,
Because-
okay,
because
okay.
there is the
Okay.
presidential
Okay.
pardon.
People
What
have
I-
been
what I-
taken
what
there
I-
and we don't know where their
Okay,
cases
okay.
are headed.
What political scores was there to settle in trying the Karamajong,
Yes.
whatever warriors?
Yeah, warriors.
What
What political
scores was there?
Well, first and foremost, I doubt the numbers that were shared in that
Okay,
letter
it's
about
okay.
the number
Yeah, I
of
never read these
Karamajong.
letters because it is a justification for easy
No, it's
feeling
okay to doubt,
existing.
but okay,
Political-
even if you use 100 as your own.
And for me, I've read one of the books where Professor Kanye Hamba says, if you're trying to have a revolution, if it's actually successful, it becomes a revolution. And if it is not, it then becomes terrorism. So for me, I could have believed that maybe the Karamojongs felt they deserve better. And we can't ignore the fact that northern Uganda, for a long time, if you looked at the history of this country, that they have had a big say in the leaders that we actually did have. I know that for a fact the likes of Moses Ali and whoever is there in northern Uganda played a big role in Museveni's coming to power. So it is also possible that it could have been a threat to him. And so for me,
politically.
that is what I would believe.
Politically.
That is
So-
what I would believe.
So
But
you're
it also
not
goes
leaving out
important-
anything in this.
No, I'm not. I actually believe
President
that
Museveni
from
came
seven,
here as a rebel. He
everything
can't underestimate
feels- he
anyone
can't
with a gun.
underestimate
You know, we
anything.
want to be a president. He came here as a rebel. You want to say
And
to
we
us
know
that
what
we
he
are
has
very
to go
young,
through.
we are very... This is a rebel who came here through the
And
gun.
so for me, if you
I've
have
told
just
you
a
that
rumor
gun read
that
the
you're going
Nairobi
to do
discussions.
something-
Whom did Museveni betray? Kaira, who was arrested, was also similar to him. But Kaira was taken to the civil court. The civil court never had evidence against Kaira. It released him. The next day is March 6th, March 1987. Kaira was killed. After going through the civil court division, the civil court, and you have no case, then 2 months later, Minister of Energy, you die because you are having charges of trying to overthrow the president who had just come into power a year ago. You know, the way presidents reduce generations to be just in their game is very dangerous. I've given you examples that go and read about him. If when he was vice chairman under Paul Mwanga, how were they handling people who are met with guns? Or those who never worked with them? Or their political opponents? Even Obote himself, how did Obote treat Kabaka Mutesa and all his followers when he felt they were now a threat to his power? How did
Okay.
It is a culture we need to fight, not create around.
Masawi, do you hold the opinion that court-martial should be overhauled? It should be removed.
I hold the opinion that court-martial should remain in the UPD
It should-
inside as a
So-
disciplinary
So it
committee.
means you have no issue with the Karamajongs, as it is alleged in the letter, being tried in the military court-martial.
Were they soldiers?
No, those who were in possession of military
If they are
equipment
civilians, they should be tried in civil
Chidega,
court.
it
in
was-
civil courts of law, right? That's your opinion.
It was
as well.
just a brain
No,
transition.
no,
that
we
now
are
those people need
we
to
are
Just answer that
we are
question.
going
That-
we,
yes.
Yes,
Let's
let
go
them
we are
step by
going
step.
systematically,
Yes.
right?
Yes, let's go
So
systematically.
we are saying that. Do you have an issue with court-martial existing?
They are saying.
Do you have an issue with court-martial existing,
don't have
being in
issue.
place?
In
There is no
the
issue.
UPDF
So-
should exist just like we have engineering boards in
Aha.
our
Yes,
engineering
good.
profession.
Good.
Because
good.
they are good
Still,
to
we may
promote
need to
quality
revise-
assurance,
Good.
ethics, integrity.
Good.
And still, we
Good.
may need to revise the fact that people there have the right to actually appeal to the appellant courts of law.
Yeah.
Because still, we do not want serving soldiers to be, oppressed and pressed from there just because they hold.
The issue of
Okay,
lack of
good.
appeal alone shows
Shows
the
that
intention.
it lacks
Okay.
legitimacy.
One last question. We appreciate this country's history. Actually, in fact, you have put it out very well for us. Our insecurity and our political turbulence as a country. And most of this has been owed to the lack of regulation on the people who are wielding the tools of violence, such as guns.
By a violent man.
No, Mama, sorry, allow us to go systematically. So if we agree that one of this country's issues has been those who wield guns fighting each other and destabilizing the country, so would the rationale make sense that therefore we need an institution or a system that can instill discipline in these officers? If we agree on that, then as a civilian, what is your intention, first of all? Yeah? Wielding guns and, I don't know for whatever reason, but you're wielding guns.
And
Either in multiple possession
Bigger.
or things like that. Haven't you, in fact, at that point declared yourself
a soldier.
an enemy of the state? Because if you're wielding a gun for purposes of fighting a legitimate government, at that point, what is your intention? And if we agree that matters of security are matters of urgency, I don't think that when the courts of law are trying a matter of theft of, I don't know,
With a gun.
a phone
With a gun. With a gun.
vis-a-vis trying a matter where an individual possessed a gun with intentions to overthrow a state, a legitimate state. Now, if we appreciate that those two matters wield different weight in terms of national security and etc., is that they therefore would warrant a quicker process for them to be tried and heard. And if you look at the backlog in our civil system,
What is causing that?
shouldn't there be an alternative that for
What is causing
that for matters that pose
And
national
for
national
me-
threat to the country?
Inefficiency
But
should
if
not
you're
be
looking at
justified.
Shouldn't we-
speeding
Yeah,
up cases,
I am-
why are we having
Let's
Olivia
listen.
retired
Let's listen in
in the
systematic
court
approach.
martial
I
for
think-
fair?
Then
It's
after-
now the moderator is giving his
No. He's asking very
So you
important-
want
I'm
us
asking a pertinent
inefficiency
question.
caused by the very government? We
Yeah,
will
to
be.
be
We will,
honest,
So the
very
point
important
is
questions that we must answer.
the decision is
Yes.
Yeah.
to either choose to be practical or choose to be ideal. The ideal is
for
that
me-
we must have efficient.
Yes, and so
System.
why are we
Civil
having
system.
that?
Deal with
Let us
matters of
address
security.
that.
Yes.
Let us
But you
address
see,
the
if
efficiency of the courts of law that we have, other than actually
Kidega,
getting
you're a
another
lawyer.
way
so
out as a
so
scapegoat.
how can we
Well, you can't create an inefficiency
Listen.
and
And
then
then
you
you
want to take
justify.
advantage of it.
Hmm?
No, that
How
is
did he
wrong.
create? Anyway, let's not go there.
You can't create backlog in the court
How does
cases
it
by
create
having
a
few
backlog?
judges. Then you said the court martial will help to
appointed
quicken the
judges. Then you
process.
said that court
Kidega,
martial is going
you
to
be
do that.
serious.
No,
on
you
certain
see,
issues.
me, I'm asking you practical questions, and my role here is to ask questions.
and
So
we
you
have
will
to
tell
be
me
I have
to
to,
answer.
I have to
possible.
leave aside my qualifications and ask practical questions here.
Yes, ask
Yes.
us.
That
Yes.
if a country is exposed to a matter of security,
Yes.
there is an attempt to overthrow a legitimate government. We all appreciate the challenges that we have in our civil courts, all right? The case backlog and etc. All right?
Let us address
So
that.
a matter, and that is why our laws provide for hot pursuit. International law provide for hot pursuit, that if an enemy breaches your territory and they're running away, the law gives you jurisdiction to pursue them, even in a new territory. Pursue them and then you return back. Because matters of security are matters of urgency. That's why international law recognizes the need for hot pursuit. So the point is that when it comes to issues of security and national defense, I want to agree that these are matters that should be put in a different class of offenses. All right? So if it is true that these are matters that should attract urgency when dealing with them, but also we appreciate that our civil court system is sufficient, then where is the delicate balance? Do we then say that if a matter has been brought before courts of law and it falls in this category, the courts, civilian or not, should give it urgent attention? Is that our proposal on this show? Or we are saying that the military court martial, because it is strictly dealing with matters of national defense and security, then those matters have to be referred there. No, these are practical things that
Let
we
me
should
hear
be talking
from them.
about. Because proposing
Let me hear from
that a civilian who has been found culpable of attempting to overthrow a legitimate government should be subjected to a process that where judgment will come in 2 years, without us proposing that, okay, can we amend the civil court regulations whereby if a case is in this category, it should be tried within a given period of time.
After how many years did the
Those are
judgment
practical
of
solutions.
Olivia Lutaya's case take?
Quite some
After,
time, yes.
no, how many years?
Masawi. 2011?
Yeah,
So
3
sorry,
years.
2020,
3
21?
years. Okay,
The
The
one-
the two around there? Yeah.
They're around 4
21
years.
around, yeah.
And
Yeah.
what is the court martial supposed to do? To speed up the cases. But I think I'll let Musari answer first.
Kidega.
Yes, Masawi.
I know you're now asking me as a graduate who has graduated in Museveni's regime, and you now think after the existence of the court martial. Me, I think before its existence. The reason me I always share the mindset of those who existed before the existence of the court martial is that even that time, the issue of security is about building a system in a country. If we are saying that we are building the civil courts as systems to be strengthened, to have capacity, then we don't need to go duplicating every response. We have duplicated things, including
with less
governance. We have
qualified
3
people.
million leaders in this country. We are now going to have very many courts in this country if we begin upholding the nature some of these things are operating. To avoid duplication, you have brought it here that the precedent set in international law. You know, Kenya also has people who don't agree with current governments, including Tom Mboya, who is the Kaira of Kenya. Tom Mboya has been named about the most famous street in Nairobi for similar actions, for standing up about freedom and democracy. When you ask me that what should be done if we feel that people who have intentions to threaten the state, if we recognize that the mission of police is to protect and serve, the mission when police arrests me, because police has also arrested people with intentions to overthrow the country and taken them to court. That responsibility, you know, our constitution was clear on even giving responsibilities until we are put in this fallacy of we need the extra courts to do extra work.
But Masawi, I asked you here whether you agree that court martial should exist. You said
I
you have no
said
issue
in
with
the
it.
UPDF, but
Now-
currently
now
it has
here-
overstretched its mandate to want to overtake as a court that is generally to determine who anyone who has done anything that they feel is
security cautious, even when you're not serving UPDF, you're the one who gave us the court cases here which set precedences. And the fact that it has no appeal system makes it a tool of what? Oppression. Chidega, you're going to be a lawyer in this country, a great one. But you need to ensure that there are systems for courts to be a place of satisfaction, a place of running to, whether you're in good or in bad, but a place for justice.
So if
Kanyeihamba was part of the Nairobi Commission that was trying to see how rebels led by Museveni and the legitimate government led by Okello here would go into a transition. But he was surprised that a few months later the man betrayed the discussions. So how do we believe that him, when he was coming, if there was a military court and landed on him, where would he be? Didn't he cause to abort all those governments? Wasn't he a security threat when overthrowing them? But if people were arrested and we built, let's avoid being reduced that the only functional court that should judge people on security threats should be the court martial. We need to work hard to see that even my local police station in Bugisu, in Bumwari, when it arrests someone with a gun, it has capacity to ensure the justice system of the country is implemented right. But not that you just had two pistols in a I've been to Riverside in the hotel he was.
We are due for a short commercial break, and very interesting. To the viewers, just don't move a muscle. We are still delving deeper and deeper into this whole court-martial situation, and of course, see you after this.
Digital rights are those human rights and legal rights that allow individuals to access, use, create and publish digital media or to access and use computers, other electronic devices and telecommunication networks. Digital rights include a right to freedom of expression, information and communication through technology, a right to privacy and data protection, a right to credit for personal works, a right to universal and equal digital access, a right to identity, a right to anonymity, a right to be forgotten, and a right for protection of minors, among others. The state's digital rights are frequently violated through various unfair actions, for example, blockage of websites and social networks, theft of credentials, unauthorized use of people's data for personal gain, privacy intrusion, online censorship, arrests and intimidation of online users, internet blockages, and the proliferation of laws and regulations that undermine the potential of technology to drive social, economic, and political development worldwide. It is hence every citizen's responsibility to respect rights of other digital users and to speak out or report to the responsible parties when one's rights are violated.
Then you want to challenge Museveni as a security issue politically.
Oh, we'll be back from that
you
short
support
commercial
his
break,
opponent.
and we shall just continue from where we had stopped. Well, Nimrod, let me come to you. The issue of the court-martial seems to be very contentious. I don't know how the convincing is going to happen for Ugandans to appreciate the need for, one, the court-martial to be there, but
We do
also
appreciate
the
it.
justification that justice can be attained in that court-martial. Well knowing the challenges with standing with regards to the qualifications, which has really been a rampant issue.
The political environment.
But, yeah, there is that too, but also the whole idea of I am a civilian who is at this point only being suspected. So how does suspicion then translate into me automatically? Why can't that suspicion be on a balance of probability, refer me to the civil processes? Why must that suspicion of me having possessed a military, whatever it is,
Suspect ab initio.
yes, why must it send me automatically to the military court martial and not to the civilian side?
Thank you. I will answer this again and again, that the jurisdiction of the court martial is unlimited when it comes to the security of the country. When the security intelligence of the country detects anything that threatens the peaceful existence of Ugandans, it must act immediately. The court martial does not try civilians who are doing anything that doesn't threaten the security of the state. an argument that talks about a civilian who is tried by the court martial and has nothing related to security of the state, I would join it. But an argument that talks about security of the country, whereby a civilian has equipment that belong fully to the UPDF, which has a mandate to ensure that this country and its territories are well protected, has no any reason whatsoever not to agree to go through the process of the court martial. Why? You have only invited them to come to you when you anyway found yourself in a security mess of the state, either by having an equipment of the security, plotting against the security in this country, or doing anything that threatens the peacefulness of Ugandans. So the issue of justice within the court martial, it is also there. You can still even appeal in the court martial itself. But also, the court martial has defendants. That even if they have taken you a civilian there, the law gives you an opportunity that you are given someone within the system of the court martial to defend you. So if you have someone who can defend you fully, some have been defended and have been relieved from their charges. So even if in the court martial, the assurance of justice is there. How? There's appeal system, and also there's a chance for you to have defendants within and outside the court martial, outside the lawyers of the court martial. But something we should not take away from all this that should not crop us, apart from, you see, one thing I've realized that some of us are discussing the biasness of the state, Museveni and all that. We should get out of that. Why? Museveni cannot be here for the next 10 years as a president. It is just biologically difficult. That after 2031, he cannot again give us more 10 years. Biologically difficult.
He'll be tired. He'll just say,
tired.
I want to go in Chiruhura and rest.
In Africa, never underestimate an African.
You get-
If death takes him by force. But if he's around,
You see, that's why I
by
said,
them, it is
He
not
can-
weak that
he can
he's
choose to
bad
go to
off.
Chiruhura.
I
He
say
can
it.
Who
I
can
say-
choose?
I
President
say,
Museveni.
Why
Yes.
hasn't he chosen for the 40 years? And
no,
if
I
it is
said,
now
I
going
said
to
by
choose?
biology
Eh,
that at least a normal African lives for 100 years.
eh.
Yeah.
Even past. Me,
Even
I've
if
had
we go-
grandparents who have been
Yeah,
past.
I'm
Yes.
saying an average. I'm using an average. Also, those are past, but those are
Because
before.
100 is so high for average.
Okay, you can
Even
use
for Uganda here.
you can use, but I'm saying there are few who get opportunities to go
Eh.
past 100.
Eh.
So by biology, what I'm trying to say is that he may not be here for over 10 years now.
Mm.
What I'm trying to say is that as we make this argument, first let's have Uganda at heart. That whoever is going through this process of court martial is threatening your existence as a Ugandan who is watching this show. Two,
They are putting the country
Two.
in a
yes, in a turmoil.
security dilemma.
Yes. Two, is that even if President Museveni is not in power, your preferred president will be in power. And he'll be in charge of this country. And these court martials will stay in order to protect even your leader that you have chosen. And that leader will act on behalf of ensuring that Ugandans are peaceful.
Are peaceful.
I assume. So the argument of this whole thing should be that Uganda is at heart, first of all. Secondly, you should get away from President Museveni because he will go. But we must have this court system stay in a sense that they are protecting interests of Ugandans. And lastly, we must also get up to some facts beyond this thing about the case that has brought all this, the Dr. Kanos's case. Trust me, President Museveni that I know, that I support, understands power than anyone else. Now this is an argument beyond the letters we're talking about. President Museveni that I understand. You see, when young people were going for demonstrations of corruption, I met with some of them, and I told them that the President Museveni I know, when you go on that street, the way he treats Dr. Kano BSJ to arrest him, they're going to arrest you, and they will not do anything. My appeal to them was, don't go on the street, use other methods to fight corruption. But when you go there, they will arrest. They arrested them. They arrested them, and you people in National Council did a good job to help some of them get what? Out of prison. This is the same thing I'm saying now. That President Museveni, who I know most, understands power. whoever threatens his existence in power, he will not give it a chance. And not because of him alone, but the country. He understands the reason why Uganda should not go back.
I was being
to where?
accused of being biased, President Museveni.
where?
Now, have you seen the justification at the
And
end?
now,
that
this
what?
is, I'm saying to
he's
the young people.
concluding.
I'm giving to the young people.
That what?
No, the
What
viewers
justification?
have seen
I'm-
it for you. No, the viewers
I'm
have
now
seen.
speaking to the young people out there that as much as you argue to issues of court martial, avoid yourself putting yourself in a situation to go there. Avoid having equipment that belong to the army or to the forces, and avoid anything that causes security threats to this country that will make you go
To the court
court martial.
Masawi, my question to you, and maybe as you either compliment or disagree with what Kakai
Okay,
is
we
saying,
compliment, I guess.
is that Senior Counsel Martha Karua is trying so hard to get a temporary practicing certificate just to appear before the court martial. A court martial that we are saying lacks jurisdiction. So how big is this controversy?
Kidega, the little I know about is that you're also a politician, and you reason for us, all youth in this country. If I'm not mistaken, you and Yeru may be the most active in all that lot of the last election in the youth leaders this country have. You know politics. Where does Martha Karua contribute to Besigye politically, and where does? It is not that all that batch of over 60 lawyers are idle who go to the court martial that they want. They are idle, including my friend Narukola and group, that they are very idle to wake up to go and say, let's stand in for Dr. Kizza Besigye. First, it is busy your profession and your duty. That any client anywhere, even if he's being tried in a shrine, he may call you as his lawyer that guide me on this, because lawyers naturally you're taught to be advisors of society, because that is why it has branches. I've been studying business law in masters in business admin, and you discover that even in it you have branches where you need to go and advise.
Structure.
So why Martha Karua is struggling for a practicing license? Secondly, first, it creates that political will that they want to challenge these courts, which is not bad. Secondly, PSG has a right to have lawyers, even to which court he has been taken. He has his right to have lawyers. Thirdly, when we sat here, given the court already exists and what, we cannot say that all because you now they are arrested, you lawyers will shun it because they know it should not be working on you. Should be. Lawyers are there to argue a case and prove facts of the case or the next future of where that case can take. Because certain cases, their future has taken different directions over time. Is why court systems and court education always has references. So that the future of certain court cases are either having a permanent jurisdiction or it will keep changing depending on the circumstances on which they will be compelled to for comparison. So first, Dr. Kizza Besigye has a right to a lawyer.
choose,
Secondly, you have a right to have your friends who want to appear as your lawyers. It is not criminal.
In a court martial
In the
that you're
court-
saying has no jurisdiction.
Chideka,
So to me the point is what contention does that create?
when I've
The
told
legitimacy question that you're challenging.
I told you from the start that the promoter, the reason it was created, has left its sole objective to be used for different purposes. I think there is, if the viewers heard me very well, that was my point. I have not said I don't support the security of this system, but I never challenged its procedural issues because it came here out to streamline. Today I know of the UPDF Act, but I avoided it because I never wanted to go into the procedural issues of any of the chapters in the UPDF Act. The issue was we need to look at the intention in the country. What is it spreading? What is the reflection? What is the cause of writing the letters by the president? Should we be in such a state where, because I've given you that the preamble of this country, all presidents have had those tools in their governance, and Museveni has been in all governments since independence.
He was wrong to say that he started in 1986. He
As
has
a
been in
president.
all governments apart from Amini's government.
I said in reference to head of state.
By that time, you said he came to government, but now you've cleared that as president. These have been tactics and tools of operation. Why should it come now that VSJ in the last 3 years was not preparing for an election until he formed the PFF and he had 2 pistols which he says belong to the UPDF in Nairobi? So doesn't the Kenya military want to have ownership of weapons which are in their country?
But you know,
Those are some of the questions the court should help guide
there
us.
is something called extradition.
Now, you see where you're taking me now. Extradition is, you're limited to clarify on that extradition. On what background and purpose do you raise that extradition on? You said on threatening national security internally here in Uganda, while basing in Kenya. Should we say that Kenya handed over and they have a certificate where they say they help? Because Kidega, first of all, we are killing the capacity of systems like Interpol, even the East African Security Council intend to go into, even the East African Court of Justice. We are making it look that if Uganda had reported to Kenya that someone had a gun in their country, illegally, Kenya would not go and arrest Dr. Kizza Besigye. So, to the viewers and the fellow young people at large, it's not that we don't want security of this, but we have gone to school. We should not come here to defend people who are gambling as judges. That is right, not to have a law degree, but judge others. Education is now very simple. A course is only 4 years. You can narrate to them how you finished. It is not a prison. You can go, study law. We need some of these amendments in the act. They will also help.
That's what I was going to say. As you blame
The
them
amendment on education will help them to know that we now don't need to go for everybody because we need to limit. Because we may be blaming when their intellectual capacity is limited on some of these issues. Because
But what is difficult with appointing the chairman of the court martial, someone, because I'm sure in the UPDF there are
he knows the
lawyers.
act.
There are lawyers in the UPDF.
I gave an
So
example.
No, I told you,
why
the
can't
problem-
we
the problem is
why can't
actually
we
not
appoint
that.
these specific individuals
Thank you.
who have a legal background
I
to be
was
the
telling
chair?
you that, you see, the problem is that it's in the Act, UPDF Act of 2005. And I was telling that if there are goodwill Ugandans who want changes and referendums or any reforms, they should start with that Act. Why? The Act just talks about anyone not below the rank of a major qualifies to sit as a judge in the court martial.
So I am saying, aren't there
Yes, even
aren't
if
there
they are
officials
lawyers,
of that rank and also at
who
the
are
same time lawyers?
You
Yes.
see, that's what
I
I'm saying.
think even on
The
the
powers doesn't, he give the powers of appointment doesn't limit
Even
to
of
qualification.
promotion to major,
Yes.
they are left to the president,
You
chief
see-
in command.
You see, the chief in command has all the powers to either appoint someone who is a lawyer, or as long as
Or
it's not
even
below.
promote you.
But
so-
in
so-
this case,
so
couldn't it be ideal for that for the appointing authority to appoint someone who
To
is
sit
both
in such a case,
no
to do what?
for someone who is both a major and has a legal background to be the
see, it's
chairman or the
It's the wisdom of the head of state to say, after the council sits and says, after the training or with the experience, we believe that these people are capable of protecting the country, carrying the country interests, and making right decisions on these cases.
But
And
these
they
are
have to
legal
do-
decisions.
So,
Okay.
The difference is that these are legal decisions.
yes, they are legal decisions.
They are
And
not
I
just
want-
any decision that
Exactly.
they're making. They are decisions that are made against evidence
Yes.
and against the law.
Yes, and that's what I'm saying. When they see that it says that so and so, we believe with their knowledge, with their training, we believe they have the capacity to understand these legal matters and make decisions
But
in the interest of the country,
okay,
which
you
are
see-
legal.
Okay, you see, Nimrod, what yardstick are you using to say that someone has the capacity to make
That
a
has
legal
been my
decision?
question
Yes.
from the start.
Thank you.
I
What
I
I'm
don't know
trying
what
to say-
yardstick you're using or the parameter. Are you using academic
He's using
qualification?
expertise in
or
the
you-
military.
or he's
No, I'm
expertise in the
using
military?
I'm using one.
You're
Hey.
good at shooting, you can catch.
I have to understand,
yes,
the
point here is
parameter.
the parameter I'm using is one that for one to qualify for a certain rank, there are processes in the army that you can read in the still in the UPD
Yes.
Act on how people qualify for ranks.
Yes.
there is the framers of the act. I'm sure they were sober enough to say we want someone not below the major rank. It's not by mistake they didn't say sergeant. Yeah.
So when someone becomes a major, is their expertise has their expertise increased on military operations?
Okay.
Or even on
No, listen,
medical?
there's what we call short courses in there.
Yes.
Yeah. For us to reach such 10 ranks, you must do so many short courses.
Yes.
And one of them is constitutionalism. As
Okay.
a short course. Yes, it's there. You can ask any major. They have done constitutionalism as a short course. It is there. It's done by either in Kawu, even here and outside here. Constitutionalism as a short course for you to qualify for certain ranks. Human rights as a short course. They do all these courses. So there is wrong for you to sit and think they don't understand what they are doing.
Anything.
They have done short courses on constitutionalism, on human rights,
Okay, now me I'm sitting here as
on public administration.
me I'm sitting now here as a lawyer, and I'm
Yes.
wondering the complexity of civil procedure in itself.
Yes.
Okay.
And I'm just
So-
wondering
so-
if someone has done constitutionalism or also human rights.
Because even
There
me,
is-
I've read the very
that
things,
is-
and I'm an
that-
engineer.
Yes, that's a
Very
drop in
basic.
the ocean
Yes,
that
very
you need to comprehend civil procedure. Like it is so
Chidega,
complicated.
Even if
I don't
read
know.
all the constitutions in this Uganda, you will remain a lawyer, I will remain Masawia Ivan. There should be that difference in paper.
Yeah.
That even if I read all the laws in this and had them on, you will remain a lawyer, I will remain.
And what you're forgetting is, I agree with, I understand your point.
Yeah.
What you're forgetting is what these people are dealing with. Yeah? The kind of cases they deal with.
Because those cases.
First
should-
of all, it's not purely law in nature. The cases they deal with
Now,
is
how
security
is
first.
that? Which court deals with anything that is not
Until
enforceable
now,
by you?
I'm telling you.
Now, why is it a court?
Wait, now we should understand.
Because the court,
The
as we
framers-
have studied any law anywhere, courts are there to enforce
I
law.
didn't
So
say
if
pure.
it's not pure law in nature,
That's why I'm
then
telling
you
you,
create-
they will arrest you as long as they
you
find
create
that.
a dilution in the statement of why they are called a court if
And-
they are not pure law in nature.
That's what
I
I'm
think
telling
it
you.
is.
Well,
you
that's what
say
I'm telling
the
you. No,
people who
what
are
I'm telling
giving
you.
judgments are not purely qualified, but don't say what they are involved in.
No,
because
what I'm
even
telling
me, I
you-
believe arresting yesterday should be law in nature.
It is a
It
legal
is law
process.
in nature.
And listen,
But again, don't reduce
but it's
the
more
judges
informed
that they are not.
more informed by intelligence than evidence. Even if
Evidence
it's law
is
in
part
nature.
of law. Evidence is part of law.
Of
There
law,
would never
exactly.
be evidence if law never existed.
Thank you. Now, that's what I'm saying is, as long as they find sufficient intelligence, sufficient what? Intelligence to deal with you, they will arrest you. The issue of was it in law to arrest you? Was it? There are so many people that have been taken there, and the argument has always been there's no case on them. Yeah, but they have been arrested by the court, the military. They are taken to court martial. But even the court martial has failed to produce evidence on them, or the issue of law is still disturbing them. But they are being dealt there. They are still there. So that informs my understanding.
I think
that-
what, if I'm understanding Masawi broadly, is that if the chairman of the court martial was a trained lawyer at the level of a judge,
He will determine what to
he
do
would
and what
he
to
would first
suspend.
of all interest himself, was basically arrested lawfully. Was there an extradition process that was met and satisfied? They would have that interest.
Procedure issues.
Procedure matters.
Procedure-
How because there are those who are saying BSJ is in fact in Uganda illegally.
Illegally. No, but that is
Because-
it in our laws.
yes.
It is here illegally.
Because he left Uganda and his passport was stamped
It was
and he
not
left.
stamped when he returned.
Are
you sure?
I don't know. I don't
That
know.
is what his lawyer said.
I don't
You
know.
want
I
doubt
don't
his
know.
lawyer who is
No, until
representing him.
I don't know.
They will argue the case, maybe.
I don't know. But
But-
with what we have seen is that he was picked.
Now,
And?
how did we know that he's here?
Now you're asking us, yet you
So-
came to defend
so-
the court martial.
So no, I didn't come to defend the court.
You've been defending
No,
the court martial.
then
Now
what
you're
I'm
asking
saying-
us
Yeah.
how.
What I'm saying is things that anyone can see, who is willing to see and willing to know. Not because I speak for court martial. What I'm saying is anything that any good
Yeah.
Ugandan can see
Can see.
and can understand. My point is that now that they don't have a judge to determine the procedural matters, their jurisdiction is clear. It's unlimited on security issues. For them, I think in that line,
You
they don't
cannot
understand the
use
procedural issues.
sparingly. That when security, they are
No,
not
when
needed.
it's- yeah.
When I'm fighting with my wife,
Yeah, no, because the
this
agents of
country is
security
having
matters.
problems.
No,
Serious problems.
the agents of
Okay.
security matters is different
Yeah.
from agents when with robbery.
True.
You get with agents of security, for example, treason, yeah, is very different with robbery. That's why I'm saying the procedural issues can be used in civil courts very well. But when it comes to a court that has no unlimited jurisdiction on security matters, they will understand procedural issues later. But the issue, at least they have contained the situation.
The situation.
Yes, they first contain,
I think
then they go through those.
I've
other
avoided
systems.
I think-
going into the
no,
UPDF
no,
Act
let
because
me
it is clear on that.
let me give an example of what Nimrod is trying to say. If a traffic officer met you on the road and you are over speeding, they're there and then issue a judgment on you.
Yeah.
They give you a ticket. They
Express.
express. It means that is a strict liability offense. Because of the nature of the offense that you're involved in, you could
I can't
expose
wait,
you
yes.
could expose all of us to risk and danger.
Danger.
That is why we sanction you there and then and punish you and say, pay this amount of money.
Immediately.
So it means that some offenses are not in the same category with others.
No, but even in formation of laws, there are those that are implied, express, quasi, and all.
Yes,
those.
yes. So I think on the argument of security, I agree that security is a matter that
Of
any
agents.
country should deal with urgently.
Exactly.
As to how they deal with the agency, whether they choose the court-martial or the civilian route,
Yes.
that I think goes back to what the legal framework of the country
I
holds.
think
So that's why the procedural issues, when you're discussing them, you must be conscious enough to know that they were dealing with purely
There is
an
a-
agent security matter.
I want to be.
that it does not go through the procedural
Yeah,
issues
but you see,
it's bringing.
rightly so, is that if UPDF is to enter Kenya, the procedurally right process is that the UPDF must apply
Yes.
through a procedure and Kenya allows them
Grants them.
I
that
wish
access.
they went Rwanda.
But where
Because Rwanda is
where
doing
Uganda is
procedural
pursuing
Yeah.
an individual who has threatened whatever offense they have committed,
Yes.
the law allows it to even violate that procedure of having to write to Kenya and first enter
Deal with the
Kenya,
matter.
deal with the matter
Then
and
we
come
shall
back.
deal with the issue.
You see, so there are cases where procedure might be first waved away, more so in matters that involve the national security of a country.
You have just made it more clear.
So
I hope you have
I
got
think
it.
to me now the question is, how do we deal with these agencies? No, so you know, how do you then deal after you've dealt with the agency? Because he is saying that after you've dislodged the security threat, then what next?
You've contained it, and then you can.
Then what next?
Exactly.
After there is the threat has been dealt with, then what next? Now, is that where we now must go on to follow the procedure?
Yeah, now there you can. That's the one.
Is that the question then?
Is human rights now coming? After
I
you
feel
contain-
very sorry for this country's legal system. It's very shame that this is how we justify that things are being done.
No, this is not about
No,
Uganda alone.
me, I'm
by the
telling
way.
you, international.
It is
I'm
not
I'm
about
giving
talk
you
of
international law. I'm telling
international
you.
law,
Yes.
Uganda going to America and picking Lumbuye in America.
Yes.
Yeah?
Yes.
And you think that will happen?
No, of
Uganda, you
course,
want to arrest
let's-
the...
let's
no,
just
I'm
practical.
international law
Let's-
should be fair to everyone.
Yes.
Don't bring... Now, why are you asking practicability? If you know it can't apply
No,
then.
no, hot pursuit
Does it limit
is a
countries?
principle of international law.
It
We
can
have seen
even
it
happen in
happening.
America.
It has happened
And Uganda can
in
go.
multiple
You have
places.
seen Rwanda pursuing
Yeah.
its enemies.
Yes.
Immediately.
Hot pursuit is a principle of international law.
You will not convince me that there is no where you will not need to organize Rwanda that I'm coming to pursue someone.
In hot pursuit,
That Rwanda will not be aware Uganda has entered Kigali because it wants
That is-
someone.
that is-
because it may not stop
in your-
you, but in the... the viewers
the-
have phones. They will review their international law and see
Yes.
procedural issues.
no, I'm telling you as someone who has gone to an international law class, and
Okay.
I'm telling you that the law
Hot
provides
pursuit.
for hot pursuit.
And that's it. So
Our biggest argument, even here in Uganda, has come from that. But the biggest news that the lawyers in the papers who are like you are busy arguing, they were asking who is determined to appear before court martial and who is not. Of which for him he has said, yes, they had weapons which belong to the what? the UPDF while in Nairobi. Yeah? I think you people here to yourselves. Yeah?
Yes.
They had weapons which belong to UPDF while in Nairobi. Yeah? And that is the reason for hot pursuit. UPDF is arms in Nairobi.
Yes.
Kenya has no laws.
No. Was,
Okay,
was it a threat to Kenya or to Uganda?
Continue.
It is a threat to Kenya.
No.
So why
If-
should
if
you think
listen,
yesterday is a more threat?
Was he being a threat to Kenya or to Uganda?
But if I have guns in Kenya and then
Yes.
you say I'm not a
And the
threat
guns
in
are used
Kenya.
against Uganda. Do you want to tell
Okay,
me that
where
those are
wa-
concerned?
now that is where the court case should go. Where was he using them in Uganda?
Auntie, that's, you see now, that's what we know. We have
That's
to
why I
wait for
tell
the
you
court to
that's where
present
the
its
political
case.
intention is. You have gone to
No,
pick him for
until-
political intention.
That's your
But
understanding.
not, you
Let's
can
wait
now
for the
tell
court
me that he had
proceedings.
guns, but he was going to use them in Uganda.
No, you see, you cannot use our own analysis. Let's wait for the court to lay its case against
I think
Dr.
that's where the argument is.
And
The
then when they
procedural
put,
issues of his arrest. But me, have decided to avoid all this because from the formation of the court martial itself, it was brought Linga into humbling. Is why it has humbled Tinyefunza, it has humbled Tumukunde. I sit with General Mugisha Muntu whenever I meet him. He can tell you stories of the friends, how humble they are these days. That they never used to call him a few years back, but they now call him to great because they are in the same boat. He has given it very clear that biology may take Museveni, and it may not. We don't want another accident to come that he ends up the NRM chairman and behaves the same. We want to have issues that are systematic, that the public doesn't take it. This from 1960. People have always interpreted that presidents deal with their opponents in such styles. This is
Yeah,
a
I don't know
mindset
that.
that needs to be dealt with. Good enough, you don't know that. But you wait the day they will take you, you will know it. Yeah? Because we are here today with you. You will be someone, even in NRM, their opponents. You will be arrested legally and someone will say, I never knew that. The issue of trying to, because the case has become more of even a political case than even what we were supposed to be debating. Why? We looked at Kitata's case with Kaihura. I brought that case because I followed it consciously. Of his golden pistol. Even when you look at the judgments where these court cases end, I gave you Bob Wine's case in Arua, the guns presented in Gulu to where the former judge of the former lead of the court martial, I think, is now retired, the fat man, Oguti. That one led us too much drama in this country when he was chairing. Full of drama. Everywhere they bring a big table of guns. Someone had AK-47. There's a case. We don't know up to there where the case ended.
Actually, just to read for you, it is provision Article 12 of the Geneva Convention that provides for hot pursuit.
How should it be executed?
Article 12. Well, it should be
no, you
reasonable.
For us there, how it should
No,
be
it's
executed.
here. It's
because
simply. It's
in law,
simply
they should define
no.
executory
They
procedure.
simply. No. Now that goes to regulations. A law is an abstract. More so, such conventions that are broad in nature. So the law simply provides that it should be done in reasonable process. That you cannot go into a country under the disguise of hot pursuit and you're spending there a full month. That hot pursuit should be reasonable. You're going there after you subdue the enemy, please retreat and leave. So it only provides for reasonable circumstances.
Okay.
Yeah. So,
UPDF went to pursue the enemy of Uganda, Kiza yesterday in Nairobi.
No. This was outside that context. I brought it in to appreciate that there are times where procedures might not be followed when there is where there is a security emergency.
I've learned that.
Yeah.
Especially on terrorism. We have seen America do that a lot. But why I was busy giving you a hard time is that you're applying it in VSJ's case. You're bringing it to be
Because
an
you're
example
underestimating
fit
it.
for purpose now, as if...
Because you're underestimating the DSG's case, which we all have no full information.
Okay, for you who is overestimating, you give us information.
No, I'm not overestimating. What I'm saying is there's no way they could go for him when he is not a threat enough to qualify for hot pursuit. It means they assessed and they found it maybe worth enough to do hot pursuit. But what we avoid to say that it should not be that way, then it means for you maybe you have a different information.
Do you know there are things which are basic? The hot pursuit, so did you offer warrants?
In a hot pursuit, like I've told you,
I want to know, does that court, does UPDF offer warrants? Like
arrest warrants.
That basically when they are coming to pick it is a warrant?
Now, first of all, the powers to arrest are powers of the police. And an arrest can be done with or without a warrant. The police can issue an arrest warrant. Naturally, it is the magistrate's court to issue an arrest warrant. Once it is issued, they can arrest you. But also the police can arrest you without a warrant. More so when it is under reasonable circumstances, where again having to go through the court system to get a whatever arrest warrant might jeopardize and the enemy might end up slipping away. In that case, you can arrest, then you present the individual before the courts of law. But that is, I think, besides our point here. The point that we are trying to assess is with regards to the procedure of the military court-martial. That, and to me, what I was trying to say is that if there was an individual with legal knowledge and background sitting on the chair as chairman, there are things that they would appreciate away from a layman's perspective of things.
Yeah, say
that
layman.
That
done constitutional. As if me an engineer, I can't do that and sit there.
Can you join the army?
That is not enough.
Now,
Nimrod, that having done that short course in human rights is not sufficient enough for you to offer judgment at that level. Judgment that requires you to weigh evidence, to weigh what the law says, because you're dealing with.
Sorry for the rights in this country.
You're dealing with a broad spectrum of laws, not just the constitutionalism or human rights. You're dealing with evidence law. You're dealing with now in this case.
Judging generals. Generals are always appearing before the majors for judging.
You see, the beauty is always a defense part of it. Let's wait. The senior councils will appear and they'll make a defense. If they think that.
But who makes the final decision?
Who makes like in other court? Who makes the final decision?
The chairman of the court martial. And me, I still insist that we need to scale up the qualification of that individual who sits
that
there.
alone makes people lose confidence in it. Let's be honest. With the current education with over 70 universities, you tell me you can't get lawyers in UPDF to chair a commission. That alone gives. He may accuse us for some of our biases, but the threshold of them is that they aren't there because it is appointment. Those you appoint, because it is by fact some of the best lawyers in this country are in the UPDF, but they have never been seen there. Yeah. And the first
I know so many actually.
David Mohos, his qualifications and grades were always super.
Yeah. He has a master's in law, in fact.
But whenever we find the scale of doing things, because such a person, you will also say that where is he taught to determine what should be heard and what should not be heard there? Where is their registry?
Okay, I think we need to get parting shots. This is a very interesting conversation, but let me give all of us 2 minutes, beginning with you, Nimrod, your 2 minutes to give us your parting shots, then Masawi.
Thank you, our dear viewers, who have been very kind to us to watch and listen to us. My conclusion is that every country will strive to protect its territories, and every system that is created by the NRM government is in the interest of Ugandans. We are the people who give the mandate to the NRM to continuously provide this. The contentious discussion we are on was provided by Parliament in 2005. It's upon Parliament that can go and revisit some of these articles that we think they are not good enough to govern our society. We know all our members of Parliament, we can reach to them, we know what to do. Let's talk to them. If it means doing amendments, let's push for that. But for now, as it is what it is. All I appeal to you young people out there, don't be a victim of the court martial. If you can avoid it, please do. And the best way to avoid it is to dissociate from things that will take you there. Having military equipment, anything that looks like that, regardless, and also plotting against the government or doing anything that causes insecurity within your community or the country at large. If we can avoid that, then why not? But lastly, we're in December, and I don't know if we shall have an opportunity to come here again in December. I want to take this opportunity, mostly to young people in this country, to wish you a Merry Christmas and a Happy New Year. I hope that we celebrate this festive happily. We join our families, we value them, and we celebrate each other. But most importantly, we protect ourselves from anything that can destroy us in these celebrations of the festive. I thank you all for being with us today, and I wish you a very nice December and Merry Christmas and Happy New Year.
Yes, thank you. Yes, Masawe.
Thank you very much, Comrade Moses and my brother Nimrod, for the show, and our viewers. Basically, as a country, we have a responsibility to choose between our consciousness, our use of our senses, and our use of our ego. We have a responsibility of always reviewing our national anthem to put it into practice, not into weaponizing anything in this country, but see that it is a key responsibility of every Ugandan, whether you think you're in a government or not, to uphold the security of this country, but also to uphold rule of law and constitutionalism. So on that background, I request that let's not only come to such discussions when Dr. Kizza Besigye is arrested, but any other Ugandan who should get justice in any court should get the justice required, but also courts should exist with clear intent of our history, not as political weapons, but courts that are there to serve Ugandans. With those parting remarks, I want to thank the production team, Paul and Group. Thank you for making the Youth Roundtable a very nice place, especially on the air. We really appreciate your services. I thank Moses, CCG, and Civic Space, and wish you all, our viewers, a Merry Christmas and Happy New Year. Thank you.
Wow. Of course, that brings us to the end of this very interesting and contagious conversation on the Youth Roundtable. From me to you, it has been a lovely 12 months appearing on this show every single week in and week out. And of course, we are in the festive season, a season for celebration, but also a season where we get to enter into a new year, this time with, of course, new resolutions, New Year resolutions, but also thank God for yet another opportunity to see 365 days yet again. Until next week, same time, same place, Merry Christmas and a Happy New Year. Bye.